Well, to get more legal insights into these two matters, Evans Ufeli joins me on the news. Thank you very much for your time. Now, Atiku Abubakar has filed an appeal at the Supreme Court seeking nullification of the judgment of the Presidential Election Petitions Court. Now, should we prepare for another legal tussle?
Of course, the option of appeal is open to all litigants. Even the parties who won at the courts can also file what they call cross appeal. What I mean is that Tinubu can also file what they call cross appeal, because there were two issues that were resolved in favor of the LP candidate, which were resolved against the APC. So for now, it is the PDP that just filed today, and that is in itself an initiation of another level of litigation at the apex court, now at the final court. The Supreme Court is going to look into what the appeal court did, that's the tribunal, presidential tribunal, and look at them carefully, whether or not the tribunal did the right thing to have held the position it held in that case. Okay, so parties are going to go back to court. The legal team of President Tinubu will also file their appellate brief and the rest of that. And all the parties in question are going back for the Supreme Court to give a final determination of this case.
All right. In another legal case, the Federal High Court has thrown out Adamu Bulkachua's suit seeking to stop the ICPC and DSS from probing him over remarks that he made during the 9th Assembly's valedictory session, saying that he does have parliamentary immunity as he had claimed, or rather saying that he does not have parliamentary immunity as the senator had claimed. Now, does the senator really have a justifiable case here?
It does not have a justifiable case, because the issue he raised in Parliament was that has to do deeply with a security issue. There's a sense in which the rules of the House precludes them from prosecution if they make statements that turn out to be litigious in nature. But the one under reference, he made these statements to the effect that he has influenced the wife, who was the president of the court before now, on several decisions for his friends who were politicians. That statement was not part of his assignment as a senator. That statement was not made in his capacity as a senator contributing to lawmaking. It was a flagrant statement that has a lot of issues, immoral and wrong issues therein. So to that effect, he's to bear the responsibility of that action. And that action, for me, was one that came so wrongly. For a senator of his standing to have made that kind of statement, it should be dealt with. It was not on his representative capacity of his constituency that he made the statement. It was a statement that he made out of a flurry of his own, exhibiting some kind of attitude that is unbecoming of a senator. And that should not go unpunished. The court should not stoop so low to now restrict a security agencies from prosecuting or for investigating into the matter. I think that judgment was right. Dismissing the suit was the right thing to do. This should stand as deterrence to others, other people who will want to do issues like that, who want to use their legislative powers wrongly, to appropriate for themselves, make statements of influence, and make statements that are actually repugnant in the floor of the National Assembly.
All right, now legal practitioner, Mr. Evans Ufeli, thank you very much as always for your insights.